Hello and welcome. Today we're going to be talking about business contract mistakes. I see these all the time. They don't have to happen. More importantly, they don't have to hurt your business. So let's talk about those, because how do you fix things? You got to first acknowledge that they're broken. That's what we're going to talk about today. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I'm happy to have you. We go live Monday through Friday at 11 a.m. to answer questions, go over a topic. Please stop in live so that we can discuss questions that you might have. I'm happy to help, and I look forward to getting to know you and getting your legal questions answered. So let's go. The number one thing that I see as a problem or mistake that people make are that they don't have a written contract at all. I know that's like my biggest nightmare when it comes to a client, because then it becomes a matter of he said, or she said, or whatever, some version of two people's opinions of a contract, which could mean that there is no contract because there's no meeting of the minds. When you're dealing with this isn't just because lawyers like it in writing. It really does come down to lawyers like it in writing because there's no mistakes, or there's fewer mistakes when you put something in writing than when you just accept it, the verbal. Now, there are certain contracts that need to be in writing to be enforceable, and because there's what's called the statute of frauds. And this is why it's so important to have most every contract in writing, because you automatically comply with the statute of frauds by doing so. So, if a verbal contract is binding in a lot of instances, not in its entirety, but the idea being that if you have it in writing, it works better than if you don't. And I've used this before, but if you're new, the principle becomes one of my law professors used to say, if it goes without saying, it usually goes better with saying. I got to think about this in that context, that it isn't just about being sure verbally, but when you put it in writing, it goes with saying, right? It goes better with saying by putting it in writing. And so you really want to take a critical look at your contracts. If you're truly in business, I see this a lot where people are kind of like tiptoeing their foot in the water of business, and they don't treat their business like a business. They treat it either like a job or like a hobby. And those two instances can hurt you long term in business, and because your attitude is different when you're using it as a side hustle or if you're using it as a job. You're not thinking strategically. You're not thinking like a business owner. Part of being involved with your contracts are thinking like a business owner. And that means approaching problems like a business owner, approaching problems like you have a say in how you run your business. That's one of the benefits of being in business for yourself. You get to the benefit of thinking for yourself and coming up with solutions to problems yourself without being told what to do. So if you're approaching your business like you would a job, where you're typically waiting to be told what to do, or you're approaching it like a hobby where it's just kind of a side thing, and so you're just dipping your toe, you're just getting your toe a little bit wet. That's fine in the beginning of things when you are just getting started, and you have to work in order to pay for your full time, the hustle. I totally get that. But once you graduate into, this is a career, this is my job, this is more than just a job, this is my ownership, this is my business, then your approach to problems are going to be different and more successful, I might add, because you're going to approach a contract different than if you're an employee, right? Or if it's just a job to you. And the big reason is because you want to reduce your liability. As an employee or as a job, you're just going to do the work and hopefully you get paid for it, right? You're not going to be thinking three-dimensionally. You're not going to be thinking four-dimensionally with time. So you really want to have a contract, and as many contracts as possible for each different type of instance, like for vendor contracts, for service contracts, for products. Everything that you do should have something in writing, and you should regularly update them and amend them to make sure that they're correct when they're needed. So that's number one. Number two, and this one I see a lot. This one is really sad because people don't realize that a contract is construed against the drafter. That means if you are intentionally vague or don't incorporate any terms or specific nature to the contract, then you run the risk of it being held invalid against you because of those terms being vague or ambiguous. Really want to nail it down as specific as humanly possible. Now, I get it. That can be annoying, right? That's a lot of work, or potentially a lot of work. But I promise you, the clearer your contracts are, the less likely you will ever have to litigate them. And litigation is way more expensive. It will make your life so much easier if you're more specific. And this kind of goes to why contracts that you get off the internet are not worth much, because they are intentionally vague. They are intentionally ambiguous. Boilerplate contracts are meant to appease the masses, but there are clauses within each type of contract that they're omitting because they can't, because it's too specific for them, for a boilerplate. And it just makes sense, right? The real issue becomes boilerplate contracts cost you more money than what they're worth because of that reason. Because if they're vague and you end up in court over a vague contract and it's construed against the person that presented the contract, then you might as well have had no contract at all, and you just spent money on a contract that was cheap and will end up costing you a lot more in litigation. I had a client like that. They had a very intentionally vague contract. They did it on purpose. They thought that if they didn't put it in there, that it couldn't be held against them. That was wrong. It is purposefully held against them. So you really have to think about how you're addressing that issue when you're considering your contracts. Is be very specific in your terms. Think through each individual contract to make sure that you are getting a specific outcome and protection for you and your business. Okay? So that's number two. Number three, incomplete clauses or inappropriate clauses. And I see this a lot with when people borrow a contract from a friend and then fill it in themselves, and they just start copying and pasting all of the different clauses from one contract to another, even if that contract doesn't work for that one. They just think by throwing it in there, it will give them protection. The other part is that they edit it and take out things that they need to have left in there. So if it's inappropriate or incomplete, so you're not adding the correct language to those clauses, may versus must, shall, all of these different languages or language options that you have that you can contract with. But if you don't draft it correctly, you're running the risk of it being an option for the other party or an immaterial portion of the contract. So it's really hard when you're talking, and this comes back to it. I'm not trying to bag on boilerplate in the sense that something is better than nothing, but in a lot of instances, boilerplates aren't much better than nothing. And that's sad because you're thinking you're protected when you're actually not. So be careful of those. The other thing I've seen happen with contracts are people, I don't know why this makes sense, but they get a contract, they draft a contract that is too one-sided. They don't think about the other side. All they're thinking about is how to protect themselves. And I get it from a protectionist standpoint, like you don't want to risk having the other side take too much and you be not protected. I get that. The problem is if a contract is too one-sided, and it's what's called a contract of adhesion. And a contract of adhesion is very simply to one-sided contract. That's the simple version of it. I dealt with this wedding photographer. They thought that, that they did. I reviewed the contract and I looked at it and I'm like, I wouldn't have their client sign it because it was so one-sided. It was just bound to be a bad relationship. And it was bound to be a bad contract. So you really want to be careful on what you're doing with your contract. So you can be too vague, which is one extreme, and you can be too one-sided, which is another extreme. And all of those issues will hurt your business in the long run. So it's very important that you kind of approach a contract as a Goldilocks experience, right? That you want to have a good, solid contract that is equal and fair for both parties. Maybe, just maybe, it's slighted more towards you than it is towards the potential client or customer or whoever you have. But at the end of the day, it's not going to be found unfair, right? It's going to be slanted, which they're going to get that. Courts understand if you're drafting the contract, you're going to draft it more slightly in your favor, but it just can't be too much in your favor. And I mean draconian in your favor. And I've seen both extremes. I've seen these with both multiple different contracts. You really want to have a more just contract because courts are big on justice, right? They want to have a fair contract that's fair for all the parties. So this idea that you can just give them, make it too one-sided or too vague or too ambiguous to help you, then these are issues that are going to prevent you from having a solid relationship with your potential client. And you're going to have the potential client screaming foul and saying that I don't want, I'm not going to do business with you after they've gotten into that relationship, and it's just going to create problems. So I found that a contract is a good indication of how the relationship's going to go. So keep that in mind. Now, the last thing that I see is that people are unwilling to negotiate on either side of it. And this is kind of an issue also because it kind of fits into that contract of adhesion. Procedurally speaking, think of if you're negotiating with Bill Gates on something, and so you accept terms that you wouldn't normally accept because of who you're negotiating with, or they try to force those terms on you. So I'm not talking substantively, I'm talking about procedurally unfair in that respect. Think of a lease for a building where the building, it's the perfect building. They know that it's the perfect building. It's for a specific purpose. It's at a specific place. So it fits all of your needs perfectly. They know that, and they take advantage of it by being the big company that's taking advantage of that purpose, right? So it's procedurally unfair. That can also be a contract of adhesion, but procedurally as opposed to substantively. Now, all of those things being said, most contracts are going to be upheld, especially if you know what you're getting yourself into. You've signed it, you've read it, or you've had an attorney review it, that type of thing. So you've got to consider this, that a battle to fight for the contract. That's why it's so important that you negotiate ahead of time and that you truly look at the issues of that contract and redline things that aren't fair and negotiate it fairly for both parties. One of the big mistakes I see a lot of clients making is they do what's called a personal guarantee. Now, in this instance, what happens is the personal guarantee is when, for instance, a company signs a lease. It's a newer company. And so they sign this lease and they ask for a personal guarantee. And what that does is it gets around the purpose of having a liability shield, like an LLC or a corporation. So you really want to be super duper careful when you're signing that, because I avoid it, pay more money, find a different place. That's how, because then if for some reason you have to break the lease, then that personal guarantee can then come back to bite you. And I've had that happen with a couple of clients, actually several, where they ended up hurt because of the way that they did it. And, they did it against my counsel. Like my counsel was, don't sign, but they're going to do it anyway. And I can't stop them. I'm not going to tell them. I tell them no with the full knowledge that they're going to do it, but they at least know what they're getting themselves into. I've had people where they didn't know what they were getting themselves into, a personal guarantee. Woohoo. They didn't know. So it ended up hurting them later. So these are all issues that I've seen with contracts and that are big mistakes or can be big mistakes. If you've gotten value out of this video, don't forget to subscribe and like. We go live Monday through Friday at 11 a.m. and tune in. We'd love to talk with you. Have a good one.